A warm welcome. My name is Jeff Handmaker, and I'm an associate professor of legal sociology at the International Institute of Social Studies of Erasmus University Rotterdam. I'm also an adjunct faculty member at the School of Law, University of the Witwatersrand in Johannesburg, South Africa. Welcome to our third webinar on untold stories about occupied Palestine, entitled The International Criminal Court, Justice Denied? These webinars aim to elevate current discussions around the application of international law and its social and political dimensions to the long-standing impasse between Israel and the Palestinians, making clear the violence that has erupted since October 2023 both has an important context as well as profound implications for the international legal order. This four-part webinar series is co-hosted with colleagues from the Legal Mobilization Platform in conversation with academic and societal partners, and has been co-organized with Francesca Albanese, United Nations Special Rapporteur on the situation of human rights in the Palestinian territory occupied since 1967, and her professional staff. During the previous webinars of the series, we have noted with shock and alarm the extensive evidence of atrocity crimes, and especially evidence of genocide committed in Gaza by the Israeli military, as well as the crime of apartheid throughout the occupied territories and in Israel. In a series of judgments in January, March, and May 2024, the International Court of Justice has demanded that Israel immediately cease its military operations in Rafah and to allow for very urgent humanitarian assistance throughout the Gaza Strip. In addition, amongst other measures, the court has called for Israel to allow for, quote, fact-finding missions, internationally mandated bodies, and/or officials, investigators, and journalists in order to assess and record conditions on the ground in Gaza and to enable the effective preservation and retention of evidence. Israel has so far ignored these demands. We'll discuss the ICJ's role in the fourth and last of this webinar series on July 1st. In today's webinar, we will discuss the role of a different apex court, located also in The Hague, the International Criminal Court, or ICC. On the 13th of June 2014, the State of Palestine referred what has become the situation in the State of Palestine to the International Criminal Court. This became the date that triggered the court's jurisdiction and from which it started investigating crimes in the territory. On the 5th of February 2021, the pretrial chamber of the ICC confirmed that the court's office of the prosecutor indeed had jurisdiction over alleged international crimes committed in the territories occupied by Israel in East Jerusalem, the West Bank, and Gaza. The latter transformed what was a preliminary examination started on the 20th December 2019 into a formal investigation by the Office of the Prosecutor of the ICC. During this period, the ICC has received extensive evidence from NGOs, United Nations agencies, and Israeli, Palestinian, and international experts regarding international crimes committed in these territories, including from the two organizations represented by our experts today. In addition, the reports of Francesca Albanese, who has co-organized this series, have made extensive reference to the jurisdiction of the ICC, including her June 2023 report, which preceded the events of October 2023, and already called for, quote, independent and thorough investigations into the possible commission of international crimes arising from the systematic arbitrary detention of Palestinians, end quote. This included what she referred to as widespread and institutionalized use of torture and cruel, inhuman, or degrading treatment or punishment, unlawful deportation or transfer, or unlawful confinement, and apartheid. To better understand these issues and the role of the ICC and other courts, we will interact with two very noted experts who can help us understand the current criminal investigation in the ICC, as well as its root causes. We're very privileged to welcome Ahmed Abofoul and Katherine Gallagher. A few words of introduction about our experts. Ahmed Abofoul is Palestinian and a senior legal researcher and advocacy officer with Al-Haq organization, one of the oldest and most respected human rights organizations in the Middle East. He's also a research fellow here at the International Institute of Social Studies, specializing in both state and individual criminal accountability. His organization also represents victims of international crimes at the ICC and in other jurisdictions. Welcome, Ahmed. We also have with us Katherine Gallagher. Katherine Gallagher is a senior staff attorney with the Center for Constitutional Rights in New York. She's also adjunct professor of clinical law at the New York University Law School. As legal counsel, she has been representing victims at the International Criminal Court. She has also been lead counsel in a path-breaking case in the Federal Court of the United States of America, representing various individuals who have brought, rather various organizations and individuals who brought a case against President Joseph Biden regarding complicity in genocide. Thank you also, Katherine, for joining us. To our listeners, to give you a heads up, after we have heard from our experts, there will be a discussion. I have activated the chat feature in Zoom, so you may pose questions at any time addressed to either or both of the experts using the chat function or in the Q&A. So I want to first of all talk about the scope of the court's jurisdiction, and my first question goes to Ahmed. Mr. Abofoul, you have followed these matters closely at Al-Haq, speaking at numerous events at our institute, at other universities, in the media, and at the International Criminal Court itself. So particularly for those unfamiliar with the work of the ICC, what is the full scope of its current criminal investigation? Can you maybe tell us a little bit about the kind of crimes that it covers?
Thank you, Jeff, and thanks to the organizers for the invitation. And it's a privilege to appear with you alongside Katie. Good to see you again, Katie. To best answer this question, I think it's important to address what we mean by the jurisdiction of the court. In the system of the International Criminal Court, jurisdiction has 4 facets. And these are the subject matter jurisdiction, as known in Latin, ragione matera, personal jurisdiction of the court, ragione persona, and territorial jurisdiction of the court, and which is called ragione locae, and finally the temporal jurisdiction of the court, known in Latin as ragione tempora. And subject matter jurisdiction, to start with, is addressed under Article 5 of the Rome Statute, and it refers to the crimes within the jurisdiction of the court, so the crimes that the court can look into. And the Rome Statute makes it clear that the jurisdiction of the court is limited to the most serious crimes of concern to the international community as a whole, namely the crime of genocide, the crimes against humanity, war crimes, and the crime of aggression. These are the 4 crimes in which the court can address within its subject matter jurisdiction. Secondly, personal jurisdiction, which is addressed in Article 12 of the Rome Statute, dealing with the preconditions to exercise jurisdiction, and entails that the court has jurisdiction over international crimes when they're committed by nationals of a state party, here the Palestinians, and when those crimes are committed on the territory of a state party, here Palestine, irrespective of the nationality of the perpetrator. So any crime committed in the territory of Palestine, the court has jurisdiction over, whether it's committed by Palestinian, Israeli, or any other nationality. In relation to the personal jurisdiction, of course, it's also addressed in Article 26 of the Rome Statute, which makes clear that the Rome Statute excludes persons under 18 years old from the court's jurisdiction. The third facet of the court's jurisdiction, to understand its scope, is the territorial jurisdiction of the court, which was one of the questions the former prosecutor asked the trial chamber before initiating the investigation. And the territorial jurisdiction of the International Criminal Court is addressed in Article 12 and Article 13, paragraph B. And as you mentioned, Jeff, the pre-trial chamber already addressed this question on 5th of February 2021, when the court determined by majority that the territorial scope of the court's jurisdiction in the situation in Palestine extends to the occupied Palestinian territory in its entirety, namely the Gaza Strip, the West Bank, including East Jerusalem. The last facet and the fourth one of the court's jurisdiction is the timber jurisdiction of the court, which is addressed in Article 11 of the Rome Statute, and it entails that the court has jurisdiction only with respect to crimes that have been committed after the entry into force of the Rome Statute, that is 1st of July 2002. So the court cannot look into crimes before that date generally. Or if a state becomes party to the statute after its entry into force for that state. So the court may exercise its jurisdiction only with respect to crimes committed after the entry into force of the statute for that particular state. Here we're talking about Palestine, and Palestine, when making a referral on the 22nd of May 2018, after a lengthy preliminary examination, it indicated that the state of Palestine wants the court to look into crimes that have been committed since 13th June 2014. So this is the date from which the court can look into crimes. I hope this briefly answers the question. So this is the scope of the International Criminal Court's jurisdiction over the situation in Palestine.
Thank you very much, Ahmed. Indeed, it does. And you've emphasized, if I may paraphrase, both its temporal jurisdiction over this really specific period of time, as well as a really broad scope of crimes that it can investigate. Those crimes contained, indeed, in the Rome Statute itself. Thank you very much. We'll be discussing the specific arrest warrants, which were recently issued, in a moment. But I want to now move over to Katherine Gallagher. So the atrocities in Gaza over the past 8 months especially have been well documented and have shocked the world. These seem currently to be the only crimes that their chief prosecutor is actively investigating at the present time, or at least prioritizing for the moment. It remains unclear, certainly in relation to what Ahmed has been saying, whether this extends to the crime of genocide. But like Ahmed, you've been following the court's work for quite some number of years, and your organization is representing several Palestinians. You've also been following the proceedings within the International Court of Justice concerning charges by the Republic of South Africa against Israel for violations of the Genocide Convention. So first of all, because I know that there's often confusion made, how does the role of the ICJ differ from the work of the ICC? And secondly, is there any relationship between these two apex courts? And as a second sub-question, can the chief prosecutor of the ICC be guided by what the International Court of Justice says? Please.
Thank you, Jeff. And it's really a privilege to be here with you and with Ahmed, although I can't believe that we're here in June talking about the horror that is still unfolding in Gaza, and really the crimes committed across occupied Palestine at this moment. So it is, while it's a privilege to be here, I really wish that these webinars were not still necessary. And that we're talking about such serious crimes like genocide. And there has been, as you noted, rulings by the International Court of Justice, known as the World Court, already 5 months ago, which should give everyone, and certainly the prosecutor of the ICC, significant pause and also impetus to move forward to stop the crimes being committed every day in broad daylight for all of the world to see. So it's frustrating that we are here talking about this, to say the least. So the International Court of Justice, just to answer the question very specifically, is a court that's known as the World Court. It's created out of the UN Charter, so it goes back to 1948. So it predates the ICC by 40 years, number of decades. And over the course of these many decades of its existence, it really has been the court that the world looks to opine on matters of international law, be it the crime of genocide, borders, territorial disputes. So it carries with it a lot of gravitas and should be looked to for authoritative rulings that guide states' behavior. And what we're seeing frustratingly again in the situation of Palestine, despite the precautionary measures that were issued in January, and then 2 more versions as the genocide continues in Gaza, we yet don't see all states responding with the level of attention and change of behavior that they need, not least of which, of course, is Israel, but that also includes where I am, the United States, which continues to send weapons that are the backbone of this genocide to Israel for use in Gaza. But the ICJ, the International Court of Justice, is one that takes on disputes between states, and that is why the case is South Africa v. Israel. It is looking at state responsibility under its obligations as signatories to a number of international treaties or conventions, as well as a limited number of kind of core customary international laws. And here, in this case, the reason why there is a proceeding between South Africa and Israel is because they are both signatories to the Genocide Convention. So that proceeding is really looking to enforce both the duty to prevent, and I think it's important to flag, because the ramifications of genocide are so serious, the destruction of a people in whole or in part, the international community back in 1948 imposed a duty to prevent. So from the moment that a state knows that there's a serious risk of genocide, international legal binding obligations are triggered. And we have been in that situation since, at minimum, late October, if not already on October 9th, 10th, and 11th, when Israeli senior officials announced the total siege, the denial of basic necessities to Palestinians in Gaza. So that is the Genocide Convention is the basis for this proceeding between 2 states. It's a contentious proceeding. And then you have, as Ahmed laid out very, very clearly, the jurisdiction of the ICC, which deals with individual criminal responsibility. So one is looking at state responsibility. It's not something that you would end up with any individual going to prison or being identified necessarily, even though, of course, state actors, presidents, prime ministers, ministers of defense are those who make state policy. At the end of the day, the ICJ makes rulings about states and the ICC about individuals. And we have seen in many instances where there is a proceeding at the ICC and a proceeding at the ICJ, or at the former incarnation, at the War Crimes Tribunal for the former Yugoslavia. There were proceedings at the ICTY dealing especially with the genocide of Srebrenica that you saw echoed then in judgments at the ICJ. Right now, we have the situation of the Gambia dealing with the genocide of the Rohingya in Myanmar or Burma, and we also have a criminal proceeding at the ICC, again at a relatively early stage. But what the ICJ proceedings should have done, and eventually did do, is really press and ignite the prosecutor to take action at the ICC. The ICC has had jurisdiction, as Ahmed said, for almost a decade over the entire territory, occupied Palestinian territory, and over that decade has been advised again and again and again, whether by the UN, by commissions of inquiry, or Palestinian civil society, of ongoing crimes that should have led to arrest warrants and the opening of an investigation far earlier than it did. Here, in this acute moment of an unfolding genocide, we already had warnings back in October of genocide by the United Nations, and it took until May after 3 sets of precautionary measures by the ICJ, for the prosecutor to feel, I guess, like there was a sufficient basis that he could move ahead. So there is some relationship of looking from one to the other, and it might shore up a proceeding at the ICC if the ICJ has already shown that there's at least a plausible case of genocide. And the two bodies might look at some of the same evidence, like commissions of inquiry or UN reports, and of course evidence from direct victims. But I think the relationship may be more at this moment on the political level, where it gives some coverage for the ICC prosecutor, who has been not been as bold, or even, frankly, as responsive as many think he should have been, to the level of criminality that's happening across occupied Palestine, and especially in Gaza since October.
Thank you very much. That's really helpful, both, again, for those non-lawyers on the group. We have a number of lawyers here, but not everyone is a lawyer. Just to recap again, the ICJ looks at states' the disputes between states, or advises the United Nations. It's doing both at the moment in relation to Palestine. And the International Criminal Court is looking at individual criminal accountability. Thank you both. This sets it up very nicely. And I would like to now move on to the second and most recent chapter in this, which is the announcement, or rather request by the chief prosecutor of the ICC for arrest warrants and the process to be followed. The request, as we understand it, was made to the pretrial chamber of the International Criminal Court. That happened last month, when the chief prosecutor Khan of the ICC requested the issuing of arrest warrants against 3 members of Hamas, Sinwar, al-Mazri, and Hania, as well as Israeli President Netanyahu and Defense Minister Gallant. So it now falls, as I understand it, on the pretrial chamber to confirm this request. So to Katherine, is this a correct reading? And if so, for what specific crimes has the chief prosecutor sought arrest warrants? I got a follow-up question in a moment.
Yes, right now there is the application pending with the pretrial chamber, who will review the, I'll call it evidence, the information that the prosecutor put forward to show that there is a reasonable basis to issue arrest warrants. And once those arrest warrants are issued, as they should be, because there is clearly more than sufficient evidence to support the crimes that we've been told underlie those arrest warrants, then they are issued to the 124 member states of the ICC, who all have an obligation to act on those arrest warrants, certainly to arrest the individuals named in them, should they end up on the territory of one of those member states, as well as to provide information in support of the ongoing investigation. And that obligation already exists for all member states to cooperate with the prosecutor. Now, in terms of the crimes, I'll focus just here because we're talking about the crimes against Palestinians. Of course, there are the arrest warrants against members of Hamas, but focusing on the arrest warrants against Benjamin Netanyahu, the Prime Minister of Israel, and Yoav Gallant, the Minister of Defense, there are crimes that are focused on only since 8 October 2023. And I'm going to focus first on just some of the positives of what we see in this arrest warrant. I mean, I do think it is a positive that we finally saw arrest warrants and an end to the decades of impunity. And of course, impunity breeds repetition, and that's part of how we ended up at this moment now of genocide. The crimes that we've been told are in these arrest warrants include the war crime of starvation, starvation of civilians as a method of warfare. This is a crime that I think is very important because starvation has intention to deprive a civilian population of food. And what we have heard over the many months by whether it's US officials or Europeans or others is talk about a, quote, humanitarian crisis in Gaza, as if there was a earthquake or a tsunami and that we're left with a humanitarian crisis. What we have in Gaza is the intentional starvation of 2 million people, more than 2 million people, because of who they are, because they are Palestinians. So I do think it's important to reframe what is happening in Gaza as starvation, as a crime, and not as simply a humanitarian crisis, and all we need is more aid. What we need is an end to the starvation of Palestinian people by Israel and how they are carrying out the siege and the closure and the assault on the population. We have other war crimes. We also have crimes against humanity, and these include extermination and persecution. And I highlight these two. Persecution is a crime that is the denial of fundamental rights to a group. And again, there is an element of discrimination embedded in persecution. It's denial of rights because of nationality, ethnicity, religion, gender, or sexual orientation. So the inclusion of persecution demonstrates that what is happening, the denial of rights, ranging from the right to life to the right of freedom of movement, which we've had going on in Gaza for the Palestinian population as a whole for 17 years because of the closure. The prosecutor is looking only since October, but I think that this crime can capture so much because it's the denial of right to family, the denial of right to education, the denial of freedom of religion. When there are so many aspects of life at this moment that are under assault and attack against the Palestinian population in Gaza, again, because they are Palestinian, and persecution is a very powerful crime that can capture that. Extermination is the other crime against humanity, which again is looking at the destruction of a population, the killing, the creation of conditions of life to kill and get rid of a population. And when you look at the crimes against humanity of extermination and persecution, they end the war crime of starvation. They look a lot like what you need to establish for genocide. Genocide is the intentional destruction in whole or in part of a group, again, targeted on grounds including nationality and ethnicity. And genocide is committed by killing or also creating conditions of life to destroy a population. And that can include denial of basic necessities like food, water, electricity, access to healthcare. And we've seen the decimation of the entire health infrastructure in Gaza with the bombing of hospitals and killing of medical staff. So I think that what is there is not only powerful in itself, and I do think these crimes are powerful, but they are also affirming of a genocide framework, even if the crime of genocide isn't named. And again, I think what is there is a very important start, and we need to see those arrest warrants acted upon quickly. There's a lot that's not there, and certainly, we don't see any crimes related to the 51-day assault on Gaza from the summer of 2014, which was the impetus for Palestine to join the ICC, which was the basis of the first preliminary examination. And we can only painfully wonder what would have happened had the ICC dealt with the 51-day assault on Gaza, which killed already, thousands of killed and maimed thousands and thousands of Palestinians from Gaza. If we had had some level of accountability for that, again, I don't believe that we would be where we are right now. So we don't see the 51-day assault from 2014. We don't see the attack on the Great March of Return that Ahmed Abu Arterma and other Palestinians peacefully led to demand their rights. Palestinians who are at this moment, again, under assault, under attack, losing family members. Ahmed lost his son. And we don't see anything of course, around the West Bank, including Jerusalem. So the taking over of homes and forcible transfer out of East Jerusalem, the attack on by settlers, the expansion of settlements, and the situation of Palestinian prisoners, which Ademir tells us is at its worst in many, many years. So there is a lot of criminality that is uncovered. I can maintain a little bit of hope that if we see some action on these arrest warrants, it will, I truly hope, break the cycle of impunity. I'll stop there.
Thank you very much, Katherine. That's very helpful. When we're already starting to get some really important questions coming in, please keep those coming. You can continue to pose questions as we finish the introductory remarks, and then we'll begin to answer your questions. So, Ahmed, your organization, like the Center for Constitutional Rights, Katherine's organization, has been submitting evidence for quite some time. So how significant really is a chief prosecutor's request for arrest warrants now? How did Palestinians respond to this announcement? Please.
Thank you, Jeff, for this question. The prosecutor's announcement of his office requesting the first ever arrest warrant in the situation in Palestine, I think, is historic and provides a glimmer of hope for Palestinian victims of Israeli decades-long international crimes committed in the occupied Palestinian territory in the context of the longest in modern history belligerent illegal occupation. So this was perceived well, and I think with cautious optimism, as it also represents a signal for the possible end of the impunity Israeli perpetrators have enjoyed for decades. Therefore, I think, as I mentioned, Palestinians have received this with cautious optimism, which is understandable, considering the length of the investigation and the permanent examination before that, and considering that this is coming at a time where the Palestinians in Gaza are facing genocide, and the very existence of the Palestinian people as a whole is being seriously threatened. Of course, it is difficult at this stage, in my view, to analyze the prosecutor's request, as there have been, I think the request itself has not been made public yet. The judges have not ruled to approve them. However, the content of the application, as appears from the statements of the prosecutor, the way in which it was announced, in my view, raises several questions. The fact that it was announced before the judges decided on them, the number of accused of each party, the types of charges prioritized and submitted in the request, amongst many other things, I think seem to indicate that this is not merely an application of the law, but also a deliberate choice intended to navigate a multifaceted political reality. And I will give a few examples to explain what I mean. And I'll do my best to refrain from delving into speculative analysis, because we don't really know much yet about the content of the application. The first point, I think, the fact that the prosecutor announced the application for the arrest warrants before the pretrial chamber issued them is an unusual practice. The pretrial chamber manual, which was issued in September 2015, makes it clear that it is not recommended for the prosecutor for such proceedings before it, namely regarding the issuing of a arrest warrant or summons to appear, to be made public. Take, for example, the situation in Ukraine. The arrest warrants were only made public after the pre-trial chamber approved them on 17th March 2023. This is the usual practice of the court. Now, again, that's why I made it clear that I don't want to speculate, but one could argue that the prosecutor did that to shift public pressure from his office to the judges, in a way, saying the matter is at the hand of judges now, and the pressure could be there. Another theory could be that the prosecutor is, of course, under public pressure because of the severity of the situation in Gaza, and needed to do something, so needed to make them public before the judges. apply? I think these are questions we'll never know the answer to, but they're merely observations. Also, the classification of conflict that was indicated in the arrest warrants, saying that there is an international armed conflict running in parallel to a non-international armed conflict is quite a unique formula, and it's not clear how the Office of Prosecutor made this determination, and until we see the request itself, it's hard to assess that. Also, if you look at the number of accused, 3 Palestinians, 2 Israelis, and the number of charges, 8 against Palestinians, 7 against Israelis, and the type of charges prioritized, of course, war crimes and crimes against humanity. For example, torture as a war crime and crimes against humanity is listed against the Palestinians, but not against the Israelis. So in a way, it is, in my view, known that the Office of the Prosecutor faced immense pressure not to apply for these arrest warrants, to the extent that the prosecutor himself received what I would call thuggish-styled threats. And here I'm referring to the infamous US Senate's letter threatening the ICC. It is possible, in my view, that some of the criticism we heard after this announcement, namely that there is no equivalence between Israel and Hamas, played a role in the nature of this application. I mean that this criticism was made before, and therefore the application came in such form and such numbers and such prioritization of charges and number of accused. So I think this could have been the reason. It is possible that this was maybe a way to preemptively address these criticism, although as we all know now, that no matter what, such criticism will persist. Notably, and here I think it's important for people to realize, some of these charges might not be approved by the judges. Even those charges approved might not be confirmed at the confirmation of charges. Also, the charges confirmed, and I conclude with that, against an accused might not pass the trial stage, and some accused could be acquitted by the court. And here we need to differentiate between 3 different standards of proof. At the issuing of arrest warrant stage, which is the current stage we're in, the standard of proof is reasonable grounds to believe. In the confirmation of charges, it would be substantial grounds to believe, which is harder than the one before. And at trial stage, the judges need to be convinced beyond reasonable doubt that a person committed such a crime. So in any way, one could properly judge such choices and the strategy within with more time, and the arrest warrants that should follow in the future, for whom and for which crimes. So only time will tell.
Thank you very much, Ahmed. And for those who have not yet done so, there's a wonderful article that he wrote in November 2023 in Opinio Juris with his colleague and director of Al-Haq, Shawan Jabarin, which delves into a number of these questions as well. So I'm actually going to go directly to our participants, because there are a number of questions which also overlap with some of the issues we've been discussing already. And in particular, a question from an anonymous attendee. And I may be going to address this to Kate. Do you think that the United States will use the Hague Invasion Act if an Israeli member of parliament would be arrested in the Netherlands?
It's hard for me to speculate how far the United States will go to protect Israel from any level of accountability. But having said that, and of course we have an election coming up in November, so we don't know who the administration will be when the arrest warrants are acted upon, if it takes a number of months. But what we've heard so far from the Biden administration is that it would not support the efforts in Congress to again, and I want to recall that the United States went to great measures already in 2021 in 2020 against the former prosecutor, sanctioning her individually as well as senior members of her staff to protect against any accountability for itself or Israel but the Biden administration said it would not support sanctions. But it still said it would support other efforts and work with Republicans and other members of Congress who are very hostile to the International Criminal Court and the issuance of the application for arrest warrants. So what that might look like, I'm not exactly sure. I would be very surprised if it was any kind of a military response on the territory of the Netherlands, which would just open up another set of challenges. But I think what we've seen is that the United States can be a bit more behind the scenes in influencing the ICC proceedings. It took, as you talked about, it took 7 years before we got the opening of an investigation, despite commissions of inquiry finding that crimes against humanity and war crimes were occurring, despite the efforts by Palestinian civil society, despite the work by legal representatives of victims laying out just a massive amount of criminality across occupied Palestine. And part of that was pressure by the United States, pressure on other states who are members of the ICC, and there are some who came out very strongly through amicus curiae briefs in 2020 when the prosecutor moved to open the investigation. So whether it's statements by Germany or Canada or the United Kingdom, statements by Austria, Czech Republic, whether it's shrinking of budgets for investigations, and there are some more hidden ways that the United States is, in my opinion, still playing a role in influencing the work plan of the prosecutor, and how quickly or aggressively or responsively, it's not even aggressively, it's responsively to crimes. So I think that there are a lot of tools, unfortunately, in the US toolbox to continue to try and maintain a situation of impunity for Israeli officials and frankly for themselves, because at this point the United States is complicit in the crimes occurring on the territory of Gaza. As I mentioned, the United States is supplying the vast majority of weapons that have been used in the assault on Palestinians to kill over 40,000 Palestinians and maintain a siege that has led to mass famine and starvation. And that's I'm only there talking about since October 8th. Of course, the United States has provided just an unprecedented level of military support to Israel and other forms of support over the decades. So I think we'll see diplomatic support continue in whatever form. I'm not exactly sure. But I do think, and this is where I'll end maybe a little bit more quote unquote positively, I do think that the United States is increasingly isolated. The hypocrisy when it comes out in support of arrest warrants for Vladimir Putin and condemns the seeking of arrest warrants for Benjamin Netanyahu, the US cannot claim to be a country that operates under the rule of law as it continues to operate with double standards. And I think what we've seen around the world, even if not yet by some governments, is a mass outpouring of support and a demand that the rights and freedoms of Palestinians be recognized. So the United States is really on borrowed time with this agenda of protecting Israel at any cost.
Thank you very much. So it's not likely, as I take it, then to use this really heavy tool of the Hague Invasion Act, but there are a range of other things which it can and is continuing to do. But as you say, and I think it's really important to note this, it's increasingly on its own when it comes to this exceptionalist treatment of international law. So, Ahmed, there is, we didn't get into the evidence in the introductory remarks, but Ferko Ori, one of the attendees in this webinar, asks, well, what about deliberately aiming to kill educators, children, and journalists? Presumably, these would be considered protected persons according to international humanitarian law. Your organization has been collecting evidence for decades, and particularly in the last 8 months. Is there sufficient evidence for this?
Yes, the short answer is absolutely yes, and that's why Al-Haq has made this clear in previous occasions that we believe it's long overdue for the ICC to issue arrest warrants. So we've been saying this for years, but I think it's important to note here that the International Criminal Court was not created to deal with every single crime that occurs in the territory of a state party, and I think it's important to explain that the court's mandate is only about the most serious crimes, and it will address those. One can only presume that the Office of the Prosecutor at the moment is mapping all the kind of crimes that are being committed and trying to address not only those most serious crimes, but also those that address or the underlying context of the current situation. So when talking about this, I think one of the most important crimes that comes to mind is transferring population into the occupied territories, also known as settlements. It's important to note that the former prosecutor has already indicated in her Article 19, Paragraph 3 territorial jurisdiction question that request that is submitted to the pre-trial chamber that such cases would be admissible. So the question is why the Office of Prosecutor is still didn't issue any arrest warrants in relation to settlements, another crime of particular importance when it comes to underlying the context of the current Israeli occupation is apartheid, which has been extensively documented and still not dealt with. So yes, there is. We believe there is enough evidence for all of these crimes. The question remains: what is the strategy of the prosecutor, and why he selected those particular crimes, and why he decided to deal with the situation only from October 7th, not before?
Thank you very much. So there was one question which Katherine Gallagher has already partly answered, which is in relation to what the complicity of other countries, the United States, the Netherlands. There was a case brought in the Netherlands relating to parts, components of F-35 fighter jets, which is now currently on appeal in the Dutch Supreme Court. And there's been a case ongoing, which both of you have been involved in the United States federal courts regarding alleged complicity of the Biden administration. So I would now like to move on to another question, which takes you more in the direction of apartheid, Ahmed, that you've made reference to already. Can the government support for legal settlements in the West Bank? And I assume that this participant, FEG, is referring to foreign governments. Can this provide some context or work as evidence in order to demonstrate the intent of genocide? In other words, and Katherine also alluded to this, so Katherine, you might also want to respond to this. To what extent do these different crimes relate to each other? Can evidence of one crime be attributed to another crime and vice versa? Please.
This for me, Jeff, right?
Yes.
Yes, no, and the crime of transferring population to the occupied territories, settlements in particular, we believe is of a particular importance. If you read the history of that crime and how it emerged, it dates back to the very origins of the international criminal law system. It dates back to the Nuremberg trials, where it was described back then Germanization of territory. It referred to the Nazi transfer of part of their own populations to other European territories in order to colonize it. As a matter of fact, the efforts that led to the drafting of the Rome Statute have described this crime before as the crime of establishing settlers. And when discussing this crime, it was mentioned by legal experts back then that this particular crime echoes the seriousness of a genocide. These exact words were used because establishing settlements is one feature of a settler colonial regime, a settler colonial ideology that is premised on the elimination of the indigenous population. So I think, of course, these are connected. It all, I think, goes back to the strategy of the prosecutor, how the prosecutor will deal with these crimes. What is the bigger strategy behind the prioritization of such crime? And here I think I have to mention that I think this is only a first step in the direction of accountability in Palestine. And that's why I said in multiple occasions, I'm really hesitant in delving into speculation of what the Office of the Prosecutor meant, because only after we see subsequent efforts we can get the full picture of what is the strategy here. So my expectation would be that other arrest warrants will be coming probably soon, and legally speaking, and as a matter of strategy, I think settlements is on the top of that list. Apartheid should be too, and only time will tell.
Thank you very much. So, Katherine, your case has been focusing on the Biden administration in the United States, and another anonymous attendee asked the question, well, is it your opinion that European leaders are complicit, for example, von der Leyen? So to what extent might it, and this is, of course, some speculation, but I suppose it's more in relation to whether jurisdictional possibilities, is there a jurisdictional possibility of addressing complicity of other European leaders?
If you're talking at the International Criminal Court, Jeff or questioner, in theory, the answer is definitely yes.
Yes.
As Ahmed mentioned, the ICC is set up to deal with those who bear the greatest responsibility. And frankly, I would put the United States and its complicity high on that list, because what we've seen through expert opinions that have gone in our case filed in California against Biden is that really the U.S. weapons are almost at a point of being critical to the ability of Israel to carry out this 8-month assault, genocidal assault. And the United States has continued to send weapons, whether it's the 2,000-pound bombs or whether it's the GBU 39s that we saw used in Rafah in the horrible, what we call Memorial Day here, the end of May attack on Palestinians who have been displaced multiple times. Those are U.S. weapons. So we've seen in cases out of the International Criminal Tribunal for Rwanda, the provision of weapons can be a form of complicity in genocide. We've seen by the International Court of Justice when it's looked at the role of Serbia in the former Yugoslavia, and highlights the provision of weapons. So I think that is something for Europeans also to look at. But as Ahmed has, I think, really tried to remind us a number of times over this 50 minutes that we're together, is the ICC is one place. And for those 124 member states of the ICC, they are obligated to enshrine in their national laws these same crimes. So the ICC is a court of last resort. It's not where you go first. It is appropriate in the case of Palestine to go against Israeli officials, because when you are carrying out kinds of crimes that the ICC prosecutor is looking at, like extermination or persecution, those have a widespread or systematic element to them and an underlying policy. So you're not going to have a government that's investigating itself when the government policy, be it for persecution or settlement enterprises or apartheid, the government policy is criminal. When it comes to Europeans, I think that there is a lot of work to do in national courts and, frankly, other places. It's not just in Europe. Israel continues to get support from different pockets, whether in a couple of countries in Latin America or a couple of countries in Asia. I mean, the numbers are fewer than they would have been 15 years ago, but there is work to do in holding our own governments and government officials accountable, and in also using universal jurisdiction. So using those laws to really create a network or a web that pushes back and captures impunity and instead converts it to accountability. And it's not only to be sending people to prison, but it's to break the mentality that crimes can be carried out with no cost or consequence, that victims can just be forgotten. I mean, there was a story that I woke up to this morning in the AP where they have documented that there are over 60 families in Gaza who have literally been wiped out. And for those families, for creating a historical record, for not having deaths be just something that we accept, this is why we need accountability. And just one last point I'd like to highlight is the role of victims in driving so much of this work. It is the Palestinian human rights organizations, and they do their work so often in the name of and with the support of and the partnership of victims and survivors, those who've lost family members, who want to ensure that their children, their fathers, their mothers, their grandmothers, the destruction of their home, their school, their community, that this is not done without any kind of historical record. So I think this is a piece that we also haven't talked about at the ICC, where we're going to see victims participating in proceedings, making interventions to try and ensure that these proceedings move forward, that they move forward accurately reflecting the level of crime and the human cost, so that these are not just labels of crimes, but these are telling what has been done to the Palestinian population, at least in this context in Gaza. So I also just want to really uplift and pay tribute to survivors and victims who, at moments of such profound pain and loss, continue to believe in a system that it is so has been so inadequate in meeting the moment, but continue to trust. And I think it's incumbent on all of us to have these systems work and really do what they need to do in stopping the crimes.
Thank you very much. And here I'm thinking not just about the historical record that you make really focus, but very important attention to. What's happening in the court is really part of this ongoing historical record. I think of the work of Noura Erakat, one of our close colleagues, who has been following also the work of the ICC for some time. There's a book that, if you haven't seen it already, called Justice for Some. Questions really the capacity of these courts, but also offers some hopeful ways of reevaluating what the role of these courts can be. So we have a question, Ahmed, from Polona. She had earlier been asking, or I assume it's a she, so asking about whether or not the incitement, why there was the Khan, the chief prosecutor, has omitted to include the crime of incitement to genocide and genocide itself. But the more recent question which is asked is, has the recent domestic cases not shown the complete inability of Western countries to hold their own nationals responsible in domestic courts, at least prevent the further support in arms sales to Israel? We've already heard some responses from Kate in relation to the United States' role in this. So I'm thinking basically in relation to dual nationals, those who have the nationality of Israel, but also of, say, the Netherlands or South Africa. South Africa has a special law, as you may be aware of, which allows the South African government to prosecute participation in a foreign country's war. It also, of course, has a jurisdiction to investigate officials. Ahmed, to your knowledge, to what extent are countries, including potentially South Africa, a country which you've also have worked in, looking into this possibility of holding dual nationals accountable? And we've only got about 2 minutes left, so it's just an allusion to what might be happening in future.
Yes, in brief, I think there have been reportings that some countries are considering that, including South Africa. I have also seen reporting of certain efforts about dual nationals in other countries. But to address the general point of the question, of course, Palestinians have a really unfortunate experience with domestic jurisdictions in European states. some of our universal jurisdiction cases, although have advanced, some countries have changed their law to prevent Israelis from being held accountable. But our belief as Al-Haq that we always engage with those legal systems. And I can assure you, sometimes there are some little wins here and there, and one can only build on them. And I think in the future we will see more of these legal efforts concluding with good results, I hope.
Thank you very much, Ahmed. Unfortunately, we have run out of time, but I think it's really important that we had addressed not only just the responsibility of Israel, but also of other states, accountability of individual officials, Israeli officials, but also the accountability potentially of nationals of other states. So it really has supranational jurisdiction. And we can perhaps maybe explore this in future webinars. I really want to thank our panelists, indeed, and corporations. That's very, very important. The court does have, of course, ostensibly, in theory, has jurisdiction also over corporations, and also third states such as the Netherlands have looked into responsibility of corporations. So we'll see what might come out of this as well. Very important. Thank you, Katherine Gallagher of the Center for Constitutional Rights. Thank you, Ahmed Abofoul of the Al-Haq organization and our Institute of Social Studies. Thank you also to online participants for your really intriguing questions. And a special thank you to Francesca Albanese of the UN Special Rapporteur and the broader organization team comprising colleagues at the Legal Mobilization Platform at the Institute of Social Studies of Erasmus University. And more specifically to Sarah Troyan, Marta Heringa, Sarah Angeroga, Jane Pocock, Isia Del Priore, and Rawan Barakat. We could not have organized this without you. Thank you again to our participants. Thank you for watching. Take care.
And thank you, Jeff.
Thank you very much.
Thank you, Jeff. Thanks.